Ready,
Okay.
go. Thank you.
Thank you, Giuseppe Martinico, Professor. Welcome, everybody. I think we can slowly start now. Good morning and good afternoon to Professor Tomás Daly, who is now joining us from Indonesia. My name is Chengxin Liang. I'm a PhD candidate here at Sant'Anna. It's a great pleasure to chair the event today. It's a wonderful opportunity to host today Professor Francesco Biagi, a professor of comparative public law at the University of Bologna. He is going to present his latest book, Constitution Building After the Arab Spring, a comparative perspective, both physically and theoretically. So this book was published, we can see the cover of this book. Yeah, this book was published earlier this year, very fresh. And today, together with Professor Francesco Biagi, we also have two wonderful discussants, Professor Tomás Daly and Professor Tamara El Khoury. Tomás Daly is a professor from the University of Melbourne. He is also a convener of the Constitutional Transformation Network and director of the Electoral Regulation Research Network, both at the Melbourne Law School. Another discussion, Tamara El Khoury is a professor of constitutional law from IE University. She also serves as a consultant at Max Planck Foundation for International Peace and the Rule of Law. And regarding our schedule for today's seminar, Professor Francesco Biagi will present his book for the first 25 minutes, followed by a discussion led by Professor Tomás Daly and Professor El Khoury. Each discussion will speak for 15 minutes, and following that, there will be a Q&A section. So this event will be recorded and uploaded to our Styles YouTube channel. So I would like to kindly remind our audience to mute your microphone at the right moment. So now the floor is yours, Professor Francesco Biagi.
Yeah, thank you very much, Xenjin, for chairing this panel. Thanks a lot to Tamara and Tom for accepting to discuss my book. It's a great honor. I'm very grateful for that. A special thanks also to Giuseppe Martinico, to Giacomo Delle Donne for organizing this webinar. I also see some dear friends, dear colleagues in the audience. And some of these people helped me a lot during the research and the writing of this book. So thank you so much for being here. I'm very happy. So the book is the result of my activities in the Arab region over the past decade. And indeed, in addition to conducting research and academic projects, I've also provided training and consultancy on various projects related to constitution building and the rule of law, to governmental and judicial institutions in different Arab countries. And most of these trainings, most of this consultancy work have been conducted within the framework of the activities of the Max Planck Foundation for International Peace and the Rule of Law, where I worked first as a research fellow and then as a consultant. And I'm very happy to see today some people in this webinar, some people that I met at the foundation, including Tamara, obviously, but also Johannes, Krusemar Cumming, Catherine Maria Scher, the directors of the foundation, Islam Mohammed. And then other projects have been conducted within the framework of the activities of the Center for Constitutional Studies and Democratic Development, with its director, Justin Frosini. So what I tried to do in this book was to combine the theoretical dimension typical of an academic book with a more practical, with a more concrete approach based on my research and this consultancy work on the ground. I don't know if I managed to successfully combine these two dimensions, but at least that was my aim. First of all, why a book on the constitutional transformations that have occurred in the Arab world following the so-called Arab Spring. The first reason is that scholarly interest has developed significantly after the 2011 uprisings. For example, with the works of Zaid al-Ali, Nimer Sultani, Nathan Brown, Nathalie Bernard-Maugiron, Tamara, just to name a few. But overall, I have the impression that the Arab region remains, to a large extent, under the radars. So Arab countries are part of those countries belonging to the global south that are rarely taken into consideration by comparative constitutional scholars. So my book aims, first of all, to contribute to shedding light to a region of the world that is often understudied. The second reason has to do with the magnitude of this new wave of constitution building in North Africa and the Middle East, because in recent years, no regions in the world has witnessed the adoption of such a large number of new constitutions and new constitutional reforms. There are even countries that have already adopted 2 constitutions after the Arab world, not just one. Like Egypt in 2012 and 2014, the 2014 constitution being also amended in 2019, or also Tunisia with the constitution of 2014 and of 2022. So for people like me who are in love with constitutional building processes, the Arab world is simply heaven on earth. Obviously, apart from joking, living in these countries is a totally different story. So a situation that is very far from being a paradise. And then the third reason is that, interestingly, in some cases, important international actors were involved in the constitution-making processes. For example, the Venice Commission played quite an important role in the process that led to the adoption of the 2014 Constitution of Tunisia, and the United Nations tried to facilitate the constituent processes in Syria and in Libya. What's the focus of the book? My book analyzes from a comparative perspective this new generation of Arab constitutions, and it focuses in particular on constitution building, which includes 3 main components. First, the process of constitution writing, strictly speaking. Second, the substantive choices made by the framers that are formalized in the new constitution, so the content of these constitutional texts. And third, the process of constitutional enforcement, the process of constitutional implementation. So I explore how these constitutions were drafted, what they say, and to what extent they were implemented. And the analysis of these 3 components, so the drafting, the content, and the implementation, represents the core of the book, the very essence of the book. I look in particular at 7 countries, Morocco, Algeria, Tunisia, Libya, Egypt, Syria, and Jordan. I had to exclude certain relevant countries, for example, Yemen, in part because I could not cover everything, but also because I did not have sufficient materials to conduct an in-depth analysis on certain countries. But I think that the 7 case studies, the 7 constitutional experiences that I analyzed in this book are sufficiently representative in order to identify the major trends, the major features that characterize this latest wave of constitution building in the region. I adopted a comparative perspective, not only because I do comparative law, but because I think that this comparative perspective is really essential in order to fully understand the constitutional developments in the region. And I decided to follow an approach by topic and not by country, because I think that this was the most effective way to identify the most important trends, tendencies that followed the outbreak of the 2011 uprisings. And the four main topics that I discussed in the book are the following. First, the constitutional making processes, the constitutional drafting processes, strictly speaking. Second, separation of powers and systems of government. Third, constitutional justice and the role of constitutional courts. And fourth, religion, women, and non-Muslims within the framework of citizenship. I also tried to adopt as much as possible an interdisciplinary approach. So even if my book is clearly a book on comparative constitutional law, I also relied very often on the contributions of historians, political scientists, and in some cases also religious scholars. And it could not be otherwise, because, for example, law and religion in this part of the world are closely related to one another, are just inseparable, I would say. I think that one of the best examples from this point of view is the fact that the King of Morocco is not only the head of state, is not only the leader of the executive branch, is not only a temporal authority, but is also the Amir al-Mu'minin, the commander of the faithful, so the highest religious authority in the country, and he claims to be a direct descendant from Prophet Muhammad. So law and religion really go hand in hand. I also must stress something which is obvious, but I think that it needs to be emphasized. With this book, I offer an external perspective of what happened from a constitutional standpoint in these countries. Because even if I spent a lot of time in the Arab region, still I'm not Arab. I'm 100% Italian. And this external perspective, I think, has pros and cons. On the one hand, probably it is easier for me to analyze constitutional developments in the region in a more impartial, in a more neutral manner. I am more distant, and therefore I am less influenced by political and by ideological dynamics. I'm not saying that I'm not influenced by political and ideological dynamics, but probably I'm less influenced. On the other hand, however, the risk of this external perspective, as always, is to miss or not to fully understand, not to fully grasp some key elements, some key features, some important details that are instead very relevant and that are very important, very clear, very evident for the people living in these countries. So I did my very best, but I was also very well aware of the risks involved in writing this book. And now a few words on the structure and the content of the book. First of all, let me stress the fact that when writing this book, I was profoundly influenced by the seminal book by Nathan Brown titled Constitutions in a Non-Constitutional World, Arab Basic Laws and the Prospects for Accountable Government, a book that was published in 2002, and that I think that can be considered like the almost an holy book for scholars interested in constitutional politics in the Arab region. So if I wrote this book and if I wrote it in this way, it was also because I was profoundly influenced by the work of Nathan. The first chapter of my book examines the post-Arab Spring constitution making processes. And here I looked at a series of variables, a series of factors, elements that influenced these processes, including the body in charge of drafting the constitution and the role played by the ruling regime. And here I drew a distinction between top-down and bottom-up processes. I also considered the degree of openness and transparency of the process, the duration of the process, the role played by political parties, the role played by the civil society, the role played by the international community and more in general the external actors. Also the influence of previous domestic constitutions and their potential reactivation. And also I consider the influence of foreign constitutional models. What I show in this chapter is that most of these constitutional making processes were characterized by significant flaws and shortcomings, a fact that not only contributed to weakening the democratic nature of the new constitutions, but that also had a very negative impact on the legitimacy and sense of ownership of these texts, and ultimately on the transition processes as a whole. And one of the main problems that I see is that in most of the cases, these processes were top-down processes, and that Arab drafters adopted, in my opinion, a short-term, a partisan perspective in most of the cases, as if they were dealing exclusively with orderly politics, and not also with constitutional politics, whereas constitutional making processes always need to be a balance, which is very difficult to achieve, between ordinary politics and constitutional politics. In my opinion, although it should not be idealized and romanticized, the process that led to the adoption of the 2014 Tunisian constitution was the only real positive exception in the region, because it was characterized by a much stronger democratic spirit. And this is quite evident for a number of reasons. The constitution, first of all, was adopted following a bottom-up process. It was adopted by a constituent assembly directly elected by the people. And also it was a constitution, and probably this is, in my opinion, a key element. This was a constitution that was, to a large extent, a consensual constitution, because it was the result of a series of negotiations and compromises between another, an Islamist party, and the secular parties represented in the Constituent Assembly. And last but not least, it was a participatory constitution, because the civil society, the people in general, played quite an important role in the writing process. And it's no coincidence that this constitution was one of the most democratic constitutions in the Arab world, or perhaps even the most democratic constitution in the Arab world. And it enjoyed, especially at the outset, at the beginning, a very high degree of legitimacy, or in any case, a higher degree of legitimacy compared to all the other post-Arab Spring constitutions. Then in the second chapter, I discuss the systems of government and the distribution of powers under the post-2011 constitutions. And in the first place, I examine the issue of the over-concentration of authority in the hands of the head of state. Again, with a partial exception of the 2014 constitution of Tunisia, which provided for a genuine semi-presidential system. And also provided for quite a robust system of checks and balances, at least from a formal point of view. Then there was a major problem of constitutional implementation. So in this first part of the chapter, I show the fact that the Arab world continues to be characterized by hyper-presidential regimes, like Egypt, like Algeria, and after July 2021, also Tunisia. And also by executive monarchies like Morocco, like Jordan. For obvious reasons, I also placed a special focus on the emergency regimes, showing that the theory of George Agamben of the normalization of the exception remains in the Arab world to a large extent the rule. And I also took into consideration the territorial organization of the state, showing that not only the horizontal but also the vertical separation of powers has remained weak. So the fact that Arab countries, in most of the cases, have maintained the tradition of unitary states, of very centralized states. And maybe during the Q&A session, I can add something more on the issue of decentralization and local government in the region. I also, in the last part of the chapter, I also discussed the main reasons for this over-concentration of authority. Reasons that include, for example, the principle of the unity of power, which remains a key principle in the region. And one of the major consequences, I think, of this over-concentration of powers of authority was to undermine the principle of popular sovereignty. And in fact, I argue that far from belonging exclusively to the people, sovereignty in the Arab world continues to be held and not only exercised, also by other subjects, in particular by political leaders and sometimes also by military leaders, as in Algeria or in Egypt. Then the third chapter is devoted to constitutional justice. And this is probably the chapter that was influenced the most from my activities in the region, as I worked a lot with constitutional courts, including constitutional courts that had just been created, such as the Constitutional Court of Jordan, the Constitutional Court of Palestine, with Islam Mohammed, with Siraj Khan. We worked a lot with the Constitutional Court of Jordan, with Sanar Sargali, with the Constitutional Court of Palestine. In this chapter, I analyzed the major changes introduced, the major innovations introduced in the field of constitutional justice by post-2011 constitutions. And I also examined the role that constitutional courts played in the transitions that followed the outbreak of the Arab Spring. I show that with a few exceptions, Arab constitutional courts displayed a high degree of deference to the political authorities, and that they still need to overcome a number of obstacles in order to emerge as effective guarantors of the principles of constitutionalism. There are even cases, in my opinion, in which constitutional courts have become instruments in the hands of the ruling regimes, legitimizing their illiberal policies. So there are cases in which the Constitutional Court has become the amicus, the friend of the illiberal ruling regime. Having said that, there are, however, a few cases in which constitutional courts did deliver judgments unfavorable to the ruling regime and demonstrated a commitment to protecting fundamental rights and freedoms. So there are some important decisions issued by Arab constitutional courts over the past few years. But I think that these rulings were just the exception and not the norm. In chapter 4, I then examined the relationship between citizenship and religion. And this is a very complicated topic. And to be honest, I had many difficulties to write this chapter. Luckily, I received a tremendous help from some Lebanese colleagues who are religious scholars, Naila Tabar and Fadi Daou, but again, I really had to struggle a lot to write this chapter. What I did, my main focus was on the status of women and non-Muslims, which are obviously some of the most vulnerable categories of the population in the region. I show on the one hand that despite some improvements, non-Muslims and women are still excluded from full citizenship, which remains a prerogative for male Muslims. And I argue that this is due, among other things, to cultural factors, but also to the predominant patriarchal interpretation of religious texts. And these two elements, culture and religion, are very often interrelated. On the other hand, however, I stressed the fact that there is an important novelty, which unfortunately has been largely, if not entirely, underestimated by constitutional scholars, by comparative scholars. Namely, the fact that over the past 15, 20, 25 years or so, some prominent religious leaders, some prominent religious institutions, including, for example, Al-Azhar, have called for a more equality-based approach towards citizenship's rights for all people, irrespective of one sex and religious denomination, on the basis of a different, on a more egalitarian interpretation of religious texts, including the Quran, in particular the Quran. And this is very evident if one reads, for example, the Amman message, the Marrakesh Declaration, also some documents produced by Al-Azhar. But I would say even more importantly, this is very evident if one reads the document on human fraternity for war, peace, and living together, which was jointly signed by Pope Francis and the Grand Imam of Al-Azhar, Ahmad Al-Tayeb, in 2019 during the apostolic journey of the Pope in the Emirates. And in my opinion, given the profound influence that religion exerts on law and society in Arab countries, these calls and these documents by these religious leaders and institutions might lead to the adoption of legal reforms aimed at reducing discrimination against women and non-Muslims, and they might represent a first step towards a full and inclusive citizenship for all. Maybe I am too optimistic, but again, this is my hope. And then finally, in the conclusions of the book, I show the numerous ambiguities, discrepancies, and contradictions characterizing post-Arab Spring constitutions. I discuss a series of dichotomies, a series of constitutional dichotomies, such as the Constitution as a charter of values and the Constitution as an instrument of government, but also the integrative function of the Constitution vis-à-vis the societal fragmentation, and also the difference between the written Constitution and the unwritten Constitution. Generally speaking, I think that my analysis was quite critical, maybe sometimes even quite harsh. But in any case, I conclude on a positive note, arguing that the Tunisian constitutional experience from 2011 to 2021, so before the declaration of the state of exception by Kais Saied in July 2021, this decade, 2011-2021, shows clearly, in my opinion, that the possibility of breaking with the tradition of previous autocratic regimes in the Arab world is not just wishful thinking, is not just a mirage, is a concrete option. And finally, to conclude, what is the purpose of the book? Generally speaking, I hope that my book can contribute to a more in-depth understanding of the social, of the political, institutional, constitutional dynamics in a region which is very difficult to understand. And this is probably the academic purpose of the book. But I also have another hope, a more practical one, because I hope that my book can offer some insights, some lessons to the countries that are now experiencing or that are likely to experience in the future a process of constitutional making after the fall of a dictatorial regime. So this is the practical, the more practical purpose of the book. And I'm obviously thinking, for example, of the case of current Syria, which is now dealing with an extremely challenging, complicated political and constitutional transition after the fall of Bashar al-Assad when he was ousted from power in December 2024. And just a couple of months ago, a provisional constitution was adopted in Syria, a text that replaced the 2012 constitution. And if you're interested, maybe I can also say something more during the Q&A session regarding this provisional constitution, which is a text that unfortunately, in my opinion, replicates many mistakes made in other Arab countries. So from this point of view, I think that the topic of the book is very timely. I'll stop here, and thank you very much.
Thank you very much, Professor Biagi, for your powerful presentation summarizing the various aspects that you cover in your book. So now I will pass the floor to our discussants. The first of our discussant today is Professor Daly. He will have 15 minutes to share with us his view.
Thank you, and thank you for inviting me to help launch this really timely and important book. It really deserves a very wide international readership. So congratulations, Francesco Auguri a te. In my 15 minutes, I want to focus on three issues: the value of comparative work like this, constitutional design and implementation, and finally, I want to say a few words about constitutional hope. But first, I think it's useful for anyone who doesn't know me to know that I come at this book from multiple angles. So my own work has focused a lot on constitution building, democratization, and democratic crisis, including in regions like Latin America and Europe. But my consultancy work has included projects in Lebanon and Palestine, and also countries adjacent to the region like Turkey. But I've also spent almost a decade co-developing the Constitution Transformation Network at Melbourne Law School, which was mentioned at the start, with leading scholars like Cheryl Saunders and Anna Djedjic. And that is a very strong focus on constitutional drafting and reform in Asia and the Pacific. Most recently, I've been thinking a lot about how we can better understand and draw lessons from perceived successes and failures of democratic transition, especially in a collection on Africa and Asia that I co-edited with Dinesha Samararatna, which was published last year. But more personally and unusually for an Irish guy, I have Egyptian relatives based in Cairo and London, so I feel a certain level of personal connection to the high stakes of constitutional reform and the political trajectories in the region. And that's intensified by the fact that my relatives are from the Coptic Christian community. So I really appreciate the attention to these issues in this book. So with all that said, obviously I'm come at this as an outsider, and my comments are offered in that spirit. So really I'm taking a comparative approach as well. So thinking about the value of comparison, I think it really is so valuable to have a book like this that helps make the whirlwind of constitutional change across the region more legible for an international audience, because it addresses what continues to be a very large gap in the literature regarding the constitutional frameworks and dynamics of these states. And Francesco, by providing this broad, cross-disciplinary and historically rooted analysis, really makes these states more visible to a wider audience, understand their complexities, and helps us to identify new paths for scholarship, and such a great resource as well for practitioners in the field. And here I think, your country case set also addresses what I tend to think of as a core periphery problem, in the sense that in many regions, the study of specific states tends to dominate. In English language scholarship here, it seems that Egypt and Tunisia get so much of the attention. I know it's somewhat broader in French language scholarship, but your book sort of helps to redress the balance a bit. And two further comments on this point. I think regional analysis is a very particularly challenging type of comparative analysis. I've recently been thinking about the regionalization of comparative constitutional studies as a cross-disciplinary field. And my dear colleague from Guatemala, Arturo Villagran, he very rightly says that it's really easy to fall into totalizing depictions of a given region. But your methodology and your account really avoid this. So I really came away from the book with a much better understanding of the commonalities among these states, but also the very real differences in how constitutional law is theorized, rooted, and implemented across these states. So you avoid presenting this as a sort of regional Arab constitutionalism, which I think would be clearly overstating the commonalities. And in doing that, your work really resonates with, for example, a recent collection on constitutional resilience in South Asia, where the editors really expressly state that they're not pushing the notion of a South Asian constitutionalism, that they're just trying to make sense of what the countries in a given region share and where they depart. That leads us to the question of comparators. Who do we compare to when we're engaging in this type of analysis outside of the region? And it's obvious that the colonial past looms large, and sets up this sort of path dependency for both academics and practitioners. You have a reflexive comparison that is often not fully articulated or thought about. Certainly, that's how it appears to me as somebody from another post-colonial state, Ireland, where we tend to compare to the UK, the former colonial power, without even thinking about it. And I think that's most obvious in the book and the influence of the French constitutional thought and models, but you also show how much countries across the region influence one another too. And I think that's really valuable in the account. That also leads us to ask, how far and how wide can comparative analysis go here to help make sense of some of the challenges in the region and the dynamics in the region? So both academically and for constitution designers in the field. I found the wider references here to states like Germany and Spain and Finland and Portugal very astute, but I think there are also clear additional pathways for what is often called South-South comparison, although I'm not sure how Arab scholars and practitioners feel about the Global South moniker and as far as it relates to the region. But for example, you point to the Latin American experience regarding judicial oversight of elections, but here we could also talk about sub-Saharan states like the role of courts in electoral regulation in Nigeria, for example, or regarding military involvement in governance. It seems that the experiences of states like Indonesia, Thailand, or Turkey could also be valuable to explore. But obviously there are clear limits and challenges here, including language and the sheer work required to make sense of countries and constitutional contexts that are deeply unfamiliar, but often the challenges facing the development of constitutionalism as values-based and capable of constraining political power are much more similar than European experiences, or certainly contemporary European experiences, or even reaching back, a century or more. That brings me to the second sort of set of comments, which is about constitutional design and implementation. So I think your book really does this great job of making sense once again of this distinction that you make in your previous work on constitutional courts and democratic transitions between formal transition, so the constitution that gets put in place, and substantive transition, actually implementing that and making it a living reality. And your new book really brings out not only the positive changes that have happened, but also the stickiness of specific institutions and practices. And others have called this the dark side of constitutional resilience, that you have the sheer endurance of these kinds of institutions and practices that run counter to democratic constitutionalism. And here I think, your choice to go by topic really, really helps you and really helps all of us to understand what's going on, because the focus on executives is so illuminating. It really seems so entrenched, this focus on sort of presidential or royal power and the over-concentration of power. And this really strong focus on command and control rule and the coercive dimensions of the state. And it doesn't take very long to see where the legacy of colonial modalities of governance and the often large raft of colonial era laws also helps all of this. And that once again is another experience that can be read over to regions like Asia. I think also, your focus on not just executives, but legislatures and courts and religious institutions in terms of how they interact with citizenship is really sensible, but you also clearly weave more institutions into your analysis. So very quickly, on courts, I think it's really helpful that you set out these key factors that have prevented or set obstacles to the courts taking on a fuller role in upholding the Constitution. And it's striking how the constitutional design options are pretty clear here in terms of what can be remedied. But you also offer a clear warning about overloading courts with ancillary functions. And I simply don't know the context well enough, but I wondered as I read this whether the sheer range of powers allocated to the Constitutional Court in Tunisia's 2014 constitution, for example, was a factor in the delays in setting it up, whether that actually creates more issues. I think it's also interesting how we see other courts taking up a more prominent role. It's not all about apex courts. So you talk about the administrative courts in Tunisia stepping in when there was this delay in establishing the constitutional court. And there's also brief mention of international courts like the African Court on Human and People's Rights. Taking action in Chapter 2. But I think here we have to be very careful about equating judicialization with democratization or the development of constitutionalism. Because, even where the courts are not government enablers, even when they are autonomous, experiences in places like Brazil and India show that without sufficient accountability, you simply set up another site of relatively arbitrary power that can serve the interests of constitutionalism or not. And it's very hard to predict how they're going to act. And I think here there are some resonances with the development of the Supreme Constitutional Court in Egypt, for example. So we have to assess their actions with very clear eyes. And I think you help us to do that. There's also the extent to which we should focus on courts as central drivers of constitutionalism at all in terms of constraining political power. So here, once again, taking a comparative view, a question is whether fourth branch or guarantor institutions, these independent bodies that are not courts but quasi-judicial in a way, could also be another stronger area of focus that you sort of set up for others to lead with. And once again, examples like Nepal and Sri Lanka become useful because Dinesha Samararatna, for example, talks about how they have been central to fostering islands of constitutionalism in Sri Lanka in a way that the courts have actually not played this role. And she calls this constitutional resilience by stealth, but I think we could call it constitutionalism by stealth. But even rather than by stealth, I think it's actually just a form of incrementalism, because it brings us back to when we're talking about major constitutional reform, we're always stuck between big bang constitutional sort of change and incrementalism. There's also the question of what Dinesha calls synergy, or what Ros Dixon and David Landau call cross-collateralization across different institutions. So your book makes us think more about the relational nature of a living constitutionalism. So, for example, where you talk about the differing roles that the Constitutional Council and the Electoral Commission played in organizing the presidential elections in Algeria in 2019, clearly you would need an independent electoral commission as well as an independent Constitutional Council. So you have to think broadly and holistically regarding how they interact. It's also interesting how you can add particular design features to a constitution, but you don't know how they will actually be used in practice. And that's not only related to, constitutional courts or fourth branch institutions, but you give this example from Morocco in Chapter 3, where the 96 constitution allowed the opposition in parliament to bring cases to the Constitutional Council, but they only used it 4 times. So that sort of sets up once again these questions about how can you ensure that a mechanism will be used? How can you incentivize its use or deal with disincentives to use it? I think one of the most useful and really valuable aspects of your account to finish out the implementation side is how you talk about the engine room of the Constitution and the unaccountable sort of shadow state that's often playing a role that is not formally recognized in the Constitution. The circle around the monarch, the military, and so on. And I think there's a big question here, isn't there, of the choice for the constitutional designer of, do you try to marginalize them or try to accommodate them? Do you try to ignore them? Or do you actually try to sort of bring them in and accord them a real role and somehow tame them and make their power more visible? That's a major question. There's also the question of, what do we do about non-state actors? I remember having a conversation in 2019 with young political leaders in Lebanon about the role of the traditional leaders, the Zu'ama, in Lebanon, and whether they should actually be brought into the constitutional structures or whether it makes more sense to embrace hybridity. And here I think comparative analysis is very useful once again to navigate some of these questions, because the relationship between traditional structures and formal state structures in the Pacific is very illuminating. People like Anna Djedjic and Balkama working in this area. My final comments, and I'm mindful of time, I wanted to finish on a note of hope, because you also finished to a certain extent on a note of hope, but not an artificial hope. So you mentioned, in your presentation, the influence of previous constitutions, and I think linking to the Tunisian constitution from 2014 as a positive example that you refer to in your conclusions, there is this growing academic discussion about interconstitutionalism, how an earlier constitution can influence a later constitution or how it's perceived. And I think it's interesting to ponder to what extent the 2014 Tunisian constitution might come to influence the interpretation of the 2022 constitution or perceptions of its deficiencies. Because once again, comparatively, we see this happening in Thailand, where the 1997 constitution is considered the most democratic constitution the state has ever had in almost 20 or around 20 constitutions. And it still is this sort of benchmark for civil society to rally around, and it sort of provides a very clear point of organization. I think it's also useful to keep in mind how where a transition is not successful or is rolled back, it doesn't mean that it's a reset. So instead of thinking about these as a pendulum, in the recent collection we published last year, myself and Dinesh Samaratna, we talk about how these democratic openings in Asia and Africa that have since mostly closed down, the system didn't simply revert, because civil society and a whole load of different institutions maintain the memory of what was possible, what was achieved, and so you have sort of a spiral of learning rather than a pendulum that goes back and forwards, and it goes in a positive direction in many ways. And I'll finish just by saying, here's where, also on the bigger scale, islands of democratic practice really come into their own. And I think your book leads us to think more and more deeply about Rojava, for example, as an example of a different type of model for democracy. And it pushes back against the notion that this region is simply inhospitable terrain for democracy, which has been a narrative coming from international observers for a very long time. But I could say so much more. I just want to say thank you so much again for inviting me to and giving me the real reason to read your book as quickly as possible. And congratulations once again.
Thank you very much, Professor Daly, for sharing your views and leading the discussion. Now I will pass the floor to Professor Tamara El Khoury. She will also have 15 minutes to share with us her views on Professor Biagi's talk. Thank you.
Thank you, and good afternoon / good morning, everyone. Francesco, I don't want to repeat what we heard from Tom regarding the, I would say, magnificently positive aspects of your work, only to insist on how successful you are in striking that difficult balance between acknowledging the specificities of each of those countries, while at the same time attempting to identify certain trends at the regional level. And as I said, it's not an easy balance to achieve. And then your focus on key topics and your comparative approach to those, I think, is not only extremely informative, but allows precisely for that regional perspective to come into shape. The way I'll go about my remarks is I will focus first on questions relating to constitution making and what you refer to as constitution building, and I'll then turn my attention to substantive elements and topics that were the major focus of the debates that the region witnessed in the aftermath of the Arab uprisings. So with regards to constitution making and the processes and this distinction you establish between top-down and bottom-up processes, I believe that one of your conclusions with regards to how, at the end of the day, there remains an extremely high concentration of executive power, you said is owed in part to those constitution making processes and how they were conducted top bottom. And while that's obviously the case, I would argue that it isn't, so to say, surprising, right, that was the outcome, because it's not like we can assume that the intent at the outset was to deconcentrate power. So in a way, I wouldn't attribute that concentration of power to the way those processes were conducted, because I assume it was as intentional as it gets. And so perhaps also from a comparative perspective, and because the countries you select, I would say, are representative of the different contexts in the Arab region in which constitution making unfolded, I think it's useful perhaps to refer to those processes in relation to context. And in that sense, it seems to me that Egypt and Tunisia, that indeed, as Tom said, have received more attention than other processes, did unfold in an extreme environment of polarization, particularly owing to the fact that democratic elections allowed, right, for Islamist movements and parties to erupt with force as a democratic force, in the sense that what lay beneath was a democratic majority, right? So there is that polarization that I think both countries witnessed, that very much informed their constitution making processes. Of course, with the major difference that Tunisia, one, saw what happened in Egypt, but two, for other factors we can go later into, managed, right, to transcend majoritarian politics and achieve a consensus constitution. But so that be one context. I would think that with regards to Jordan, Morocco, Algeria, Bahrain too, even if it's not part of the analysis, it is, and I think he used the term survival constitutionalism, useful to look at it from that perspective, but also I would emphasize the term preemptive. These were largely preemptive constitutional reforms aimed at containing, right, what was perceived as a threat of popular uprisings that other countries were witnessing. And it's not an irony again, but if we actually look at how those constitutions look after those preemptive constitutional reforms, not only did they not democratize, right, those systems, if anything, they have consolidated power. If you look at Jordan, the remnants of whatever parliamentary monarchy were in place on paper have been dismantled. In Bahrain, I think this concept of the shared sovereignty, you referred, right, to the fact that sovereignty remains held, this concept of shared sovereignty people and the monarch has embedded itself. And one would think that constitutionalism is not ignored. It seems in this case that constitutionalism actually is pinned against democracy, but in a very clever attempt, right, at embedding power in that formal constitution that excludes any material considerations with regard to, to social demands. So I do think that this idea of preemptive constitutional reforms is interesting in looking at those processes from a comparative perspective. And then I would turn perhaps to a third category. And of course, you very much focused in Libya and said you excluded Yemen for understandable purposes. But those are countries that fundamentally have witnessed what can be referred to perhaps as on and off constitution making, right, for the past decade or so, in, and this is important, right, a context of ongoing conflict. So I think that from that perspective, it's interesting to engage in their constitution making processes by looking at broader attempts at really ending conflict or peace building. And the reason I refer to that context and why it might be helpful, and maybe to add or introduce a little note of optimism at this stage, is that with regards to both Libya and Yemen, you refer to the Libyan 2017 draft constitution. Yemen too has a draft constitution. These are countries that remain, right, in conflict to larger or lesser degrees, but where I would not dismiss, right, this kind of constitutional or constitution making or building record, right, they've accumulated over past decade. And so what I think is an interesting concept to bring in those contexts is this idea of incremental constitution making, and this idea that interim constitutions have been, I would say, overlooked, or their role has not been considered carefully in our region. Whereby interim constitutions, say the Constitutional Declaration of Libya back in 2011, or the Supreme Armed Forces Council in Egypt's constitutional declarations, were, of course, adopted as interim arrangements, but because the manner in which they were adopted was by no means inclusive, consultative, etc., understandably so for certain reasons, what that meant is that it increased pressure, right, for a permanent constitution to replace those interim constitutions, not allowing the space that an interim constitution typically is meant to allow for consensus building. So you referred to, Francesco, right, to all those rushed constitution-making processes, constitutions delivered within 6 months, etc., as part of why that consensus just could not emerge. And I would think that this should invite us to think of interim constitutions more deliberately as instruments that can be useful if well designed to buy enough time. And I'm thinking too, Francesco, of Syria's constitutional declaration at the moment, and we can discuss all the negative aspects during the Q&A, and there are many of those, but I think one positive element is the fact that it foresaw a 3-year transition period, which at least seems to suggest, right, that it is perceived as buying time for that longer consensus building process. On the question also, Francesco, of transparency, you do discuss how open or closed those assemblies were, particularly, of course, when looking at bottom-up constituting processes, Egypt, Tunisia, etc. I think that one interesting element that we witnessed in the Arab region is how actually the publication of draft constitutions played a major role. Also as an instrument of transparency, but also, I would say, of effective or broader participation. So I was thinking, and I remembered, right, as I read basically what happened in Tunisia, I'm a bit skeptical, Francesco, as to the degree to which, say, the Venice Commission was influential. I would argue that if we recall that first draft constitution that was published, that had incorporated Sharia as a source of legislation, that had referred to the complementarity of women with regards to men, I would argue that it was much more the massive mobilization of civil society against that draft, right, that ultimately added an external factor to that constituent assembly that was democratically elected, but in terms of preempting, again, majoritarian politics, so to say, right, in favor of a broader consensus. So I think that how drafts were published, released, played an interesting role. Same goes for Libya. First draft constitution, December 2014, helped mobilize civil society and have something to react to. So if we compare, say, to other constitution making processes, particularly in Africa, right, and we have colleagues from Max Planck Foundation here who can say more, a lot of those processes were designed such that draft constitutions could actually be commented upon by the public. So this was a deliberate step, right, and mechanism of public participation. This was never the case from a formal perspective in the Arab world, but I would argue that informally they did play that role. So there was a question of transparency. I wonder what would have happened if the Constituent Assembly of Tunisia had never released a draft, and I wonder whether, Sharia would have remained in the constitution, and how much influence other members in the Constituent Assembly would have had to alone convince the other party, had it not been for the pressure coming from the outside. So maybe something to consider, right? How draft constitutions can play a role both as an instrument of transparency, but also in kind of rendering public participation a bit more effective. Tons of things, because it was really thought-provoking, Francesco, and it was like a kind of a nice summary of the decade we were all witnesses to as I read through the book. But I'll move now on to maybe a few questions regarding content. And I, again, to agree fully with Tom, believe that your focus on the question of executive power and the detail with which you discuss how it's been reinforced time and again across the different constitutions was crucial, because it remains the kind of overarching reality that executive power remains concentrated to the degree it does. I think that because you also analyze Tunisia's choice of a semi-presidential system in a in a lot of detail, right? I think it's interesting, again, from a comparative perspective, to look at how semi-presidentialism at the time, and I'm thinking at the beginning, in Tunisia, Egypt, and then Libya engaged in constitution making, how it was theorized. And again, one thing is the manner in which it was theorized at the regional level, another is why or for what reasons, as you yourself mentioned in Tunisia, they ultimately opted for a semi-presidential system. But what's interesting, again, from a comparative perspective, and bearing in mind, as Tom said, the influence, particularly the French influence, right? In a lot of those countries, is that the way it was theorized was very different from how semi-presidentialism has evolved in France since the Fifth Republic, and has moved away, right, gradually but deliberately, from cohabitation, right? That the whole purpose of aligning elections was to avoid cohabitation. And what's interesting from a comparative perspective, and I think a genuine attempt at the regional level to avoid hyper-presidentialism, but also acknowledging the limits of a parliamentary system in countries that lack political party culture, was to say, let us purposefully design semi-presidential systems that precisely guarantee political pluralism, not only in the sense of an alternation of power, but that will force, right, a cohabitation of political parties at the presidential and prime minister level. So in a way, I think that's been underlooked, but this genuine attempt at theorizing a semi-presidential system that precisely does what the Arab region has lacked always, which is to allow, right, for multiple poles of power to be in power at the same time, is worth looking at, even if in practice, Tunisia's semi-presidential system, for a lot of reasons, also because parliament was given a lot of powers, failed, right, in practice, or at least, has unfortunately now been replaced by an unabashedly, right, hyper-presidentialist system. I'll move on to two more ideas, and again, I don't want to speak for too long. I know there'll be a lot of questions for you also from the participants. One has to do with this role, right, that has come up also with regards to constitutional courts. And I completely agree with Tom's remarks about how one ought to be careful in terms of assuming that constitutional courts will necessarily side with constitutionalism, so to say. And again, of course, the Egyptian Supreme Constitutional Court is a case at hand. But I would also think, and this ties with my next remarks regarding the question of citizenship, Francesco, which I agree with you is the most complex of questions, that these courts have played an important role in actually being that institutional check, not necessarily vis-a-vis the regimes in place, but in that tension, that constant tension between efforts at Islamizing the system, right, and the state repressing also at times those Islamist movements. They have very much played the role of institutional check, but also in striking, right, that balance, particularly through the way in which Sharia, references to Sharia, have been interpreted. And I would argue that is an integrative also function, Francesco, not so much in terms of an integrative constitution versus elements of society, but in a way in resolving that eternal tension in the region between religion and the state. So we tend to focus on the kind of literal, right, reference to Sharia and whether it's a source or the main source. But I would argue that unless we look at how constitutional courts, right, have actually interpreted Sharia and integrated it, it remains an incomplete picture. And again, Egypt in that sense offers a lot of interesting, right, case law that has drastically reduced in practice the role of Sharia in legislation. And I'll come to my last remark, and it has to do, as I said, with this complex question of citizenship. Francesco, I do agree with you that although there were references to citizenship in the past, the way in which, right, the concept emerged during these debates that followed the Arab Spring was unprecedented. I think, though, that Another concept that at least we're working with at the Arab Association of Constitutional Law in an attempt to unpack it, but also to explore alternative routes to constitutionalism in the region, is the concept of the civil state or the civic state. So for Arabic speakers, الدولة المدنية. And you see, it's not a coincidence. This is not a made-up concept by scholars, but every time a protest erupted in the region, people would spontaneously chant Dawla Madaniya or Madaniya. This happened in Sudan, it happened in Algeria, it happened in Egypt, and happened in Tunisia, right? It even made it into the Tunisian constitution. That was a famous article too, that Tunisia is a civil state. And why do I say this is a key concept? And in my mind, an entry point into engaging, right, with Arab constitutionalism, not only from the perspective of this idea of citizenship in the liberal tradition, but from the perspective of a region attempting at reconciling, right? Those tensions between religion and the state and the role it ought to play in it. And Dawla Madaniya can be understood both as a concept used to confront the military state, the security state, so it's civil as in civilian oversight, but at the same time to confront the religious or Islamist state, in that it is a state that, and it's useful because it avoids terms that can be very controversial, such as secular, laïc, that can, also be confounded at times with like atheism and therefore rejected socially. But again, if you were to ask an Islamist or a civil society activist, or it's not like it's a defined notion, and yet it keeps coming back time and again, and it's in every constitutional debate, and it's in the debates that happened in the streets, not just amongst legal scholars. So we have been, very much looking at how different countries have approached the concept, both at the level of the constitutional text, but also in practice. What does an Islamist mean when they claim they're in favor of the civil state? And all this to say that it seems to me that there are genuine attempts at reaching constitutionalism. Francesco, as you said, what Nathan Brown wrote 20 years ago probably still stands. But it seems to me that this idea of the civil state is, in my mind, more than a concept with clearly defined contours, an instrument towards that constitutionalism that remains elusive, because it means that, in a way, and that's what constitutionalism does, right? It contains democracy. And I'll end with this remark, but I think it's worth reflecting on. When Tunisia, and this was a major innovation in the region, adopted its famous Article 49 in the 2014 constitution, which allowed, right, to limit rights only to the degree that their essence is respected, it said that those limits ought to be acceptable in a civil democratic state. And it's no coincidence, as I was saying, that the article was upheld in the 2022 constitution, but which of the two words was omitted? Civil. Why? Because it seems that that's the limit on democracy. It seems counterintuitive, but it would seem to suggest that, it's not the majoritarian option of the 2012 Egypt constitution. It's an understanding that there's a minimum core to citizenship rights that democracy cannot trump. And so I think, to conclude, that any further explorations of Arab constitutionalism ought to maybe focus a bit more on this concept that is really unique to the Arab world. It's not imported, it's only used in constitutional Arab debates, and is worth further exploring. And otherwise, thank you for this wonderful contribution, and happy to hear your thoughts.
Yeah, thank you so much for sharing your views and leading the discussion. Now, for the sake of time, we have more or less 20 minutes left. We are opening the Q&A section, but at the meantime, I would like to invite Professor Biagi to address a comprehensive intervention to the comments and questions raised by our discussants. But at the same time, I invite everybody to raise your digital hands to reserve your slots for our Q&A sections later. Thank you.
Yeah, thank you. Thank you very much, Tom. Thank you very much, Tamara. I think that I have already materials for a second edition of the book on the basis of all your comments and observations. So really, thanks a million for that. I will pick only some of the elements that you raised in order to leave time also for the questions and comments from the audience. I'll start with you, Tom, and what you said with respect, to the influence of former colonial powers, in particular, the influence of France, of French constitutional law. I would say, in particular, in the case of the Arab world, not only the Maghreb, but also the Levant. If we think, for example, of Jordan, the influence of the 2008 constitutional reform. This was really a profound influence, but yeah, also regional influences that should not be underestimated. I agree with you. Probably in my book, I did not engage a lot with a South-South comparison, as you mentioned. There are some references, as you said, for example, to Latin America, to South Africa. But yes, this is probably an element that I should have considered more. What I can tell you is that what I've noticed, and I think that is one of the most interesting features and characteristics, if we look at a number, not all, but a number of post-Arab Spring constitutions, is the mix between elements typical of global constitutionalism and elements aimed to stress the national identity of the country. So if we look at post-Arab Spring constitutions, we will see that the language has changed, at least in part, with respect to previous constitutions. There are many references, to the idea of citizenship, to the idea of human dignity, a robust protection, at least from a formal point of view, of fundamental rights and freedoms. This reference, to the Dawla Madaniya. So in general, there are elements, that recall in a way or another, the global constitutionalism or the global constitutionalism discourse. At the same time, the references, to national identity, to the Islamic religion, in some cases to Sharia clauses, in some cases also the fact that the countries belong to the Maghreb, for example. These are elements typical of national identity that are equally stressed. So it's interesting, to see that the drafters at least tried, from a formal point of view, to combine global constitutionalism in order to show the fact that the constitutions were, at least from a formal point of view, again, in line with certain international standards and comparative best practices, but at the same time, they also put a greater emphasis on national identity. Then another point, Tom, that you raised was about, the ancillary functions. Yes, I mean, obviously, the fact that constitutional courts have been granted a number of ancillary functions is something that is not only typical of the Arab region. I'd say that is a general trend, from a comparative point of view, but certainly, the Arab world is not an exception from this point of view. The case of Tunisia from this perspective is very interesting. You are right. The Tunisian Constitutional Court under the 2014 Constitution was supposed to be a key actor, really a key actor in the country. It was granted with a number of key prerogatives, including, for example, the power to resolve disputes between the prime minister and the president. And during the first parliamentary term from 2014 to 2019, there were a number of tensions between Sabsi and the different prime ministers that alternated. The Constitutional Court was not there, and it could not solve these tensions. Also, the Constitutional Court was granted the power to review the extension of the state of exception. Here is where, you know, Tunisian drafters relied on the new Article 16 of the French Constitution, which vests the Constitutional Court with the power to review the constitutionality of the extension of the state of exception. When Kais Saied declared and then extended the state of exception, the Constitutional Court was not there. One can argue that Kais Saied would have abolished the Constitutional Court. Is a very valid argument, but still, I mean, at least in theory, it could have played a role. It was not there. So if you ask me whether, you know, the presence of such a high number of ancillary functions was a factor that hindered the establishment of the Constitutional Court, I would say that indirectly, yes, because, I mean, the drafters were well aware of this key role. And that's the reason why the political forces within parliament could not find an agreement, did not reach the 2/3 majority necessary in order, you know, to appoint 1/3 of the constitutional courts. If the Constitutional Court had not been such an important actor within the state apparatus, probably, you know, this majority could have been reached, you know, more easily. With respect to the engine room of the Constitution, the Sala de Máquinas della Costituzione, according to the well-known definition, expression of Roberto Gargarella, here I think that if there is, I don't know if you agree, but here, if I think that if there is a feature which can be seen not only in Arab constitutions, in recent Arab constitutions, but in a number of constitutions all around the world, is the fact that drafters have focused a lot on the part of the constitution dealing with rights and freedoms, but have not sufficiently paid, you know, have not equally paid attention, you know, to the institutional part of the constitution, the one dealing, you know, with the system of government, you know, with the checks and balances. And as Gargarella explains, there is one part of the constitution, the institutional part, characterized by this over-concentration of authority, that works against the other, the part devoted to fundamental rights and freedoms. This is, in my opinion, one of the most important reasons explaining why in the Arab world, in a number of countries, in Latin America, in Africa, in Asia, there are so many problems when it comes to constitutional enforcement. You also made reference, you know, to the concept of interconstitutionalism, and I fully agree with you, Tom. By the way, this is an article written by two dear colleagues, Jason Mathone and Cem Techimer. I fully agree, you know, with their analysis. I do believe that the former past constitutions can play a role, can really play a role, from this point of view, I do think that the 2014 Constitution of Tunisia, I hope in a near future, can be used, if not reactivated, at least in some of its parts, but at least can be used as a point of reference for future constituent debates. I'm fully convinced that it is impossible, you know, to replicate, to reestablish the status quo, and this is something that should not be done. But in the light of the fact that we do have, Tunisians have such a profound democratic constitution, at least they should draw inspiration from it again in a near future. Hopefully in the near future. And again, talking about interconstitutionalism, let me also stress the fact that the preamble to the current provisional constitution of Syria does make reference to the 1950 constitution of Syria, the post-independence Syrian constitution. I don't think that it is a coincidence, and in my opinion, it is one of the positive elements of this constitutional document. Tom, I don't have the time, you know, to fully address the issue of Rojava that you mentioned, but again, this is an important element. And again, talking about the provisional constitution of Syria, the Kurds living in Rojava have already rejected, you know, the provisional constitution, because it does not. This is a constitution that does not make reference, does not recognize the presence, of the Kurds in the country. Tamara, a number of questions, a number of comments. Thank you very much. Where can I start? Well, I fully agree with most of what you said regarding constitutional making processes, the issue of polarization. These are, very important issues. I also agree with you with the importance of draft. The importance of interim constitutions, the various interim constitutions that alternated over the past few years in Arab countries, and I do agree with you that they can be, very important documents, at least in theory, can be very useful. I also fully agree with you that if there is a positive element of the current constitutional transition in Syria is the fact that instead of adopting a permanent constitution, at least they opted, to have a provisional constitution. This is something which should not be underestimated. I also agree with you that should not be underestimated, these incremental constitutional making processes, the efforts that have been made in some very complicated contexts, such as, for example, in Libya, the 2017, draft constitution of Libya, again, is very important not to be underestimated. Well, if I have time, maybe I will say something more regarding Libya. Draft constitutions and also the role of the Constitutional Court. In order not to be misunderstood, Tamara, I agree with you that the role played by the people was in the constitutional making process in Tunisia was much more important than the role, for example, played by the Venice Commission. And having said that, I do think that the Venice Commission played quite an important role also in some very sensitive areas, such as, for example, with respect to the issue regarding the relationship between state and religion. If Tunisia, together with Lebanon, was one of the few constitutions in the Arab world that did not explicitly mention that Islam was the state religion, it was also because of the recommendations, the opinions made by the Venice Commission. So the draft constitutions are very important because they are an essential element to guarantee an effective people's participation. Fully agree with you from this point of view. Semi-presidentialism. I mean, I had this debate with a number of colleagues, so I fully understand, your or your concerns, your doubts, and in part also your skepticism, to a certain extent. Having said that, I mean, if we look at the current scenario, the current context, I'm convinced that probably this is, at least for the time being, a good balance between, the type of the type of systems of government that we have seen over the past decades, in the Arab world. I'm fully aware that it's far from being a perfect system, but at least in the case of Tunisia, it guaranteed, it contributed, to marking a discontinuity from the previous hyper-presidential system. So in my opinion, it can be considered, a good compromise.
Sorry to interrupt, Professor.
I'm done. 30 seconds and I'm done.
Sorry.
Okay, I'll skip. Okay, just one thing, concerning to Sharia. It's not so important, to look at whether, a country contains or not, a Sharia clause. I don't think that this is, the most important point. What is even more relevant is to see what is the institution responsible for interpreting Sharia and what kind of interpretation this institution is going, to give. And from this point of view, the case of the Egyptian Constitutional Court is interesting. I had many more things, to say, but I'll stop here.
Yeah. Thank you so much. I see the hands from our audience. So it's Captain and Tommaso. please, we can collect more and then give the floor back to Professor Biagi. So, Iso, can you start your mic and ask your question? Thank you.
You mean me? Sorry. Can you
Yes,
hear me?
yes, we can hear you well.
You mean me? Okay. Thank you very much for the presentation and for the really thought-provoking discussion. So I really learned a lot. Actually, the question I wanted to ask about the also Professor Tamara was mentioning the preemptive constitution, preemptive process as well. So I would like to comment about the survival cycles of those constitutions that emerge after the Arab Spring, because I don't know if all the constitutions are like this, but ultimately the constitution making process in this region were the outcome of a crisis, as we know. But do these constitutions have the ability to survive in normal times after the crisis? Because as you said, in this region, law and religion may go hand in the hand, but more than in any region as well. But there are also sectarian conflicts between the religions. So it's also interreligious issue as well. So, for example, you cited Tunisia 2014 constitution as a good example because it was participatory after the Arab Spring. But when we come to 2022, it was abolished. A new constitution was adopted with the, low voter turnout. Maybe I can say this, not the participatory as before. So, and it's also bringing the high presidential system, maybe for the semi-presidential one. So I would like to hear your evaluation if there is a long-term viability and survival skills of those constitutions drafted post-Arab Spring period as well. And the second question, you were thinking about especially in Tunisia and Lebanon, and the reason that there is not written in the constitution, this is not Islamic State, is related to Venice Commission, but I was not quite sure about this because I'm not sure about Venice Commission has that kind of impacts in terms of this issue. So I just would like to hear about your opinions. This.
Yeah. Thank you so much. And also, Kevin, please open your mic and take the floor.
Yes, thank you very much to the speaker in both discussions. I learned a lot about this topic. I'm not a constitutional lawyer myself, but a political scientist. This will also, let's say, influence my question. So the question really is about lessons that we can learn from the Tunisian experience for processes of constitution making. Now, if I understood you well in your presentation, you were referring to Tunisia as kind of a positive example, at least in relative terms, to other constitution making experiences post-Arab Spring. And there can be little doubt that this interpretation is correct, even though I think we should also not forget that the Tunisian experience was not without contention, right? And I think Professor El Khoury has pointed this out in her remarks that there was civil society resistance, and the reason why the very thorny issue of Sharia in the constitution was turned out the way it was had, of course, to do with this mobilization. But across the board, I think there was this participatory process. Yet it seems, it is very clear that this constitution was not sustainable. And one interpretation that I would like to propose to you and just get your reaction on is that it seems to me that in the relatively hurried way in which the final constitution was then put together in the context of a major political crisis in Tunisia in 2013 and 14, specific issues that seem to be very linked to identity and these kinds of questions, in particular the issue of Sharia and religion, were overemphasized with regards to questions that you spoke about in terms of the engine room of the constitution, right? Actual design issues of specific constitutional institutions such as the Constitutional Court. I would also add the Tunisian version of semi-presidentialism and prerogatives of parliament to this. And so it seems to me that there was such an emphasis on these big questions of religion, gender equality, these kinds of things, that the more technical aspects were a bit neglected. And I think this came back to kind of with a vengeance in the constitutional crisis, the extended constitutional crisis after 2019 in Tunisia. I was wondering if you had a reaction to this interpretation. Thank you.
Thank you. And also, Tommaso, please open your mic and take the floor. Thank you.
Yes. Hello, Francesco. Really, congratulations for this book, both for the content and the structure as has been discussed. and also for the methodology of sociological jurisprudence that you adopt, which is, I think, unavoidable, especially in this part of the world. And I would like to connect especially to this aspect and to your last sentence about Sharia and the importance of those who interpret it more than having or not having a clause. Don't you think that there is still a point of entry of an external legal system into the civil one when a Sharia clause is in place, and this creates a danger per se, irrespective of the interpreter? For instance, in the case of the Supreme Constitutional Court of Egypt, Bernard Maugiron makes it clear that in some cases, although it was obiter dicta, the court interpreted certain rules as absolute rules of Sharia, specifically, for instance, including women's clothing. So even when you have a sort of reformist or interpreted as such interpreter of Sharia, there is still the possibility that the Sharia clause becomes a loophole in the system. And in connection to this, I have a question on your fourth chapter. Given your approach, which is, as I say, the right approach of sociological jurisprudence, you say that if we reach certain advancements on the cultural and religious level, this can reflect also on the legal level. However, if you take the document on human fraternity, for instance, Cucurella, who is the former director of PISAI, and Dominique Avon criticized the document because it's basically an entente bilaterale between two religions that excludes freedom of conscience and significantly excludes those that you correctly call third-class citizens. And you are aware of that because you write about Al-Azhar in the book. And I would like to remark that Al-Azhar has kept criminalizing apostasy over and over again. So don't you think that there is a danger in relying on religion to achieve civil rights, no matter who is behind the religious interpretation? And my second question, very quick, do you agree with Sana Ben Ashur that in general, in the constitution, in the letter of the constitutions of the Arab world, as well as in the application of their rules, there is a fundamental confusion between state of emergency and state of exception? Thanks.
Thank you. And also to Sana, please open your mic and take the floor. Thank you.
Thank you very much. Can you hear me? Yeah,
Yes, we can hear
perfect.
you well.
Well, congratulations to Professor Biagi, to Francesco. It's an excellent book. I enjoyed reading it. And I think it's one of those books that when you read it at the beginning, you get scared because somebody who's not Arab writing about the region. But I have to say that Francesco spent enough time to understand how the dynamic works, which is excellent. And I like the title that and the way he approaches it in a constitution building angle, which is different than the drafting. So congratulations, because this distinction is very important and it's not that much discussed within the contents of the Arab world. Reading through the chapters, which I agree, I like the structure, I like the flow. I was just wondering if there is a need to have, in the next volume, of course, a chapter only separated, only about sectarianism in the Arab world and how it's connected to the constitution building and how it's connected also to the drafting, since sectarianism is connected to everything that was discussed, the religion, the tension, the psychology, the society, etc., etc. The other question I had for Francesco, which is related to all the updates that occurred in terms of like of the whole region. Do you think with the current update that the final conclusion will make a difference, or will it change in your book, or you will leave it as it is? Thank you very much, and congratulations again, and thanks also for the discussions. It was very, very enriching conversation.
Thank you. And also to Macchiata, please take the floor. Sorry, Macchiata, you have a question to ask?
Thank you. It's Mayeka. Thank you so much. So I thank you to the author and the discussants. I think the presentation was very good. I just have one concern, and I think it's really linked to what Isel asked, that you see after a push for reforms, especially within the Middle East, after a constitution is enacted and there is a big difference between the expectation of what the reforms was to bring and what the outcome is. So my question to that is, I don't know, do we need to revisit the idea of when they are pushed for reforms, it is an automatic push to have a new constitution, to looking at what are the specific issues that were raised within the reforms and address it more of an incremental way of constitutional making instead of overhauling the whole constitution in the process of kind of addressing the challenge being raised. Thank you so much.
Thank you for your question. I'm sorry to you with the question, Professor. Now the floor is back to you. Thank you.
Yeah, thank you so much. I mean, we are already out of time, so we'll keep it very short. Isil, thanks a lot for your question. I think it's a very, very important one. Well, what I can tell you is that certainly in the vast majority of the cases, these constitutions did not meet the aspirations of the people. The expectations have clearly not met. If we consider, the type of the manifestations, the protest movements, what people requested, during the, in the end of 2010, beginning of 2011, certainly in most of the cases, these aspirations were not reflected in these constitutional documents. I mean, I use an expression, referring, for example, to the case of Jordan, Morocco, but maybe it can be applied also to other countries. I use the expression surviving constitutionalism. So the fact that in a number of cases, these documents were adopted in order to guarantee the survival of the regime. This was, the key point. So you were asking, whether, this the chances, that this document, will survive, in the long term. I would say that at least in the short term, these documents managed to guarantee the survival of these ruling regimes. For example, when it comes, to Morocco and Jordan, the kings, are still there. I'm not so sure whether, this kind of approach, this kind of constitutionalism, will serve, also in the medium and long run. I'm very skeptical about that. And here, I mean, if I get time, I could say, more about, the role played by monarchies, but I don't have time to do that. Your second question was about the role played by the Venice Commission with respect to the relationship between state and religion. Again, this is very much related to the draft constitutions that were released by the Constituent Assembly before the final version of the Constitution was adopted. When the fourth draft Constitution was released by the Venice Commission, by the Constituent Assembly, the Speaker of the Tunisia Constituent Assembly requested an opinion of the Venice Commission. In some cases, the recommendations of the Venice Commission were not taken into consideration. But there were some issues, including, the one concerning, the relationship between state and religion, in which, the Constituent Assembly did follow its recommendations. It is true that there were also other institutions that had recommended, to make certain changes. So it was not only because of the recommendations of the Venice Commission, but certainly, at least this is, the perspective, the feeling that I have, certainly the Venice Commission played a role. Kevin, if I have correctly understood your question, you were asking whether there was especially, but there was, in general terms, during the constitutional making process, an excessive emphasis, on big issues such as, religion, you know, the system of government, and so on and so forth, and less attention on technical, you know, issues, technical details. Well, in part, yeah, I mean, this was partly, you know, the case, even if I must say that Tunisian drafters at a certain point decided not to depart from certain rules that they had decided at the very beginning of the process. For example, one was about the duration of the process, because at the beginning of the process, when the process started, the idea was that it should last no more than 12 months, so 1 year. They realized, however, that that time was not enough, was not sufficient, and that's in fact demonstrated by the fact that eventually the process lasted, you know, 2 years and 2 months. In my opinion, this was crucial in order to guarantee a democratic constitution at the end of the day. So not respecting certain formal rules was essential to guarantee at the end of the day a better outcome. Tommaso, thank you very much for your questions regarding, you know, the Sharia clauses. Yeah, I mean, the discussion with respect, you know, to the role of the Egyptian Constitutional Court, you know, the difference, you know, between, you know, the absolute and relative principles of Sharia. Yes, you're right. But I mean, if you look at the approach of the Egyptian Constitutional Court, you can see that only in a very, very few cases the legislation was struck down because of its incompatibility with the Sharia clause. So only in a very, very few limited of cases, you know, the Egyptian Constitutional Court relied on the idea of absolute principles, you know, of Sharia. And why? And this is another key aspect, because again, as Bernard Mogiron explains, Article 2 was never or almost never considered a supra-constitutional principle. It was considered, you know, a key principle, a very important principle, but together with all the other provisions of the Constitution. And this explains, you know, this approach of the Egyptian Constitutional Court. I understand what you said with respect to the document of Union and Fraternity. What you mentioned regarding the fact that it excludes, it does not make reference to the freedom of conscience is absolutely right. This is one of, in my opinion, one of the biggest problems of the vast majority of Arab constitutions, but also the fact that this document excludes other categories of people. I mean, what I'm trying, you know, to say is simply the fact that for the first time, in my opinion, this is one of the first times in which we have some religious leaders that show the path, at least, towards an idea of full citizenship. It has major weaknesses. Some people, you know, are not included. Certain categories of the population are excluded, and so on and so forth. But at least a first step has been taken compared to the past. This is what I think. Sana, yeah, I mean, I will try to add a chapter on sectarianism. I understand also why you are suggesting that. Would I change my conclusions in the light of the current developments in Syria? Not at all. Not at all. On the contrary, I mean, I think that it confirms, you know, my what I try, you know, to suggest in the book. And Makieka, with respect to the incremental approach, yeah, I agree with you. You know, sometimes having maybe a constitutional amendment, a constitutional reform, or a limited constitutional amendment, a limited constitutional reform can be much better than you know, having a brand new constitution. But you have to understand again that the approach in a number of cases of Arab leaders is very clear. Every time the constitution, the existing constitution, does not entirely correspond to their political project, they just change, you know, entirely the constitution, because I mean they want like to start, you know, a new deal, also, you know, from a symbolic point of view. So I understand, you know, with what you are saying, but at least on the basis of what I've seen, on the basis of what we can see, you know, in the region, it is very, very difficult, you know, to occur. Thanks a million, you know, to all the participants for all your excellent questions, and obviously thanks a lot again to Tom and Tamara.
Yeah, thank you so much.